Indemnity and defense. No two words in the architects and engineers and insurance community gather more attention than those two words. There's good reason for that. The two reasons are, first of all, indemnity and defense is all about shifting risk, and particularly financial risk, on a project. The second issue is that it shifts liability often disproportionately, and most troubling, it oftentimes leads to uncovered or uninsured risks. Let's take a look at those two issues as we go forward and try to really address this and develop a strategy for going forward. And we'll do that in reverse order. The first thing is to understand that a poorly drafted or overbroad indemnity and defense clause can lead to an uninsured risk, a risk for which you do not have that all-important financial protection. The reason for that is that most professional insurance liability for the last 20 or 30 years has included what we call a contractually assumed liability exclusion. By that it means that if you take on a liability by contract which you would not otherwise have by providing the services, it may be outside your insured risk and therefore your own exposure, your own responsibility. The second part is that owners and other parties frequently will take an indemnity and defense clause and extend it beyond what your proportionate or actual responsibility is, beyond that liability and risk you can control and should be responsible for, and seek to make you an insurer or an indemnitor for other issues. For both of those reasons, we need to study and really understand these concepts and get into that. Let's start with some definitions. Indemnity. Indemnity is a fancy word, but what it really means is to reimburse. If there's a third-party claim made against somebody and they think that someone else is responsible, they seek reimbursement. That's indemnity. That's actually the easy part. It's the defense part that carries even the greater burdens, because there it would require the hiring of lawyers, the engagement of experts, and the incurring of all of that financial expense going forward from the very beginning of the claim potentially, and even before there's any finding of fault or responsibility. It's important to understand that that defense obligation can come up in two ways. Directly, by the word defend, that classic defend, indemnify, and hold harmless language, or more cleverly, more susceptible to confusion or misleading when it comes in the form of covering attorney's fees, experts' costs, and defense. In either situation, it is a liability beyond what would be under the common law and outside of the contract, and potentially something there that would be outside of insurance, and a tremendous potential financial impact to the firm. Because it is so important, we want to get into it, and we really want to understand how it comes together. In fact, across the country, many legislatures have gotten into this. They've revised it. In California, for example, they've now issued new statutes trying to control and contain this liability, to essentially have architects and engineers protected from themselves and protected from their clients. So no matter what state you're in, you want to consult with your local council, your local statutes, and figure it out. But no matter what, there are some prevailing and common concepts that should apply to any indemnity and defense obligation. Really, 5 core concepts that can lead you to a fair, equitable, and appropriate indemnity and defense clause. The first of them is the trigger. What's being covered? And because it is what you're insured for, because it is the area of responsibility, it should be built around the concept of negligence. Not any random act or error, because you're not supposed to be perfect. It's that negligence that falls below the professional standard of care. That should be the covered issue. It should be proportionate, and that's one of the offenses of many of these indemnity and defense clauses. They will make you responsible not just for yourself, but for other people as well. And so to make it proportionate to your share of the fault or the responsibility is absolutely critical to what's taking place there. To also take it and limiting that defense obligation. As we've talked about, either the direct defense obligation or the responsibility for experts, for attorney's fees and so on, can create an exposure which can be beyond the insurance. We want to limit that. The best way to do that would be to simply say there is no defense obligation and to leave it solely to indemnity. The other practical reality is that working with clients, that can be difficult. And so a back door to that is to limit that to the extent that it is either arising out of our sole negligence, which would be covered by insurance generally, or to the extent covered by the applicable insurance coverage. The next issue is really to make it an actual causation event. We will see many of these clauses that will talk about actual or alleged fault. That can be dangerous. And so what we want to have is actual causation, cause and effect. And the final fifth factor that we want to look at is appropriate parties. Many of these clauses will open with a laundry list of people to be covered: agents, representatives, third parties. It should be limited to the client or those for whom there is a reasonable basis to cover them. Based on those 5 principles, I want to leave you with 2 sets of clauses, 2 sets of words that will really guide you forward. The first is 8 simple words, and if you can build these into every indemnity and defense clause that you have, you'll be in pretty good shape. Those words are: to the extent, actually caused by, consultant's negligence. To make it proportionate, to make it based on actual negligence, and to tie it to that performance. The second are like it, to limit that defense, that indemnity obligation, to the extent covered by applicable insurance. If each and every one of your indemnity and defense clauses could include those words, you'll be in good shape. The final admonition to you is really to remember that any agreement you enter into is a two-way street. It's a relationship. It's between 2 parties, and nowhere is that more important than this indemnity clause. If you were being asked to step up to an indemnity and defense clause covering your proportionate fault, your proportionate responsibility, your client should do likewise. Reciprocal or mirrored images of these indemnity and defense clauses are a solid foundation to a balanced relationship and will protect you well into the future when those problems arise. Thank you very much.